Good morning and welcome to Employment Hour in 30. I'm John Scholes, Lior Samfiru. It's easy to get a hold of Lior anytime. I'll give it to you right off the top, 1-855-821-5900. help@employmentlawyer.ca. That is for email. First time joining us, this is what we do. We talk about your rights, your workplace rights, everything underneath that large umbrella of what you do 8 hours a day, probably for 40 years of your life. So it's an important show. So if you haven't listened to us before, Lior, give us some broad strokes of what we do here and what the show's all about.
Yeah, so I'm an employment lawyer. Yep. John, I'm not on TV that often. Most of my time I spend in my office working with people that have workplace problems, but that's what this show is about. We're here to talk about workplace issues and workplace rights to help people solve those problems, or at least help them understand what they're owed, what their rights are. Maybe you're sitting there on the weekend now having a bad week because your boss did something or said something, and you're not understanding, you're not sure what your rights are. Well, stay tuned to us today. Every week we'll talk about those rights, we'll answer questions, we'll talk about various tools that are available to you to find out what you're owed and what your rights are. And of course, throughout this, if you do want to talk to me privately, just the two of us, we'll give you my contact information, email, phone number, so that you can reach out to me and we can discuss your matter specifically. This is an important show.
Yes.
A lot of misconceptions out there about workplace rights, about employment law. So hopefully you can learn something and be educated about those things. And we like to start off every week, John, talking about a situation that came across my desk over the past few days. So I'm going to do that. We talk often on this show, John, about severance, about the compensation that people are owed if they lost their job. And the reason we talk about that so frequently is that there's so many misconceptions and so many landmines out there for people when they don't understand what they're actually owed. And we want to try to resolve those issues so no one ends up losing tens of thousands of dollars that they're actually owed. So let me tell you about a situation like that where kind of disaster was avoided. I spoke with a gentleman who recently was let go. He had worked for 3 years as a graphic designer. Now, you don't need to be reading the newspaper every day to know that graphic design is an industry that's not booming right now. Everything is digital, etc. So because of that, this person was let go. There was just not enough work for him. And he had some major concerns, legitimately, that he's going to have a hard time finding another job. Now, when he was let go after 3 years, he was offered 4-week severance. He did what a lot of people do in this situation, and we'll talk about that more throughout the weeks, but he called the Ministry of Labor. And he asked the Ministry of Labor, here's my situation, am I getting the right compensation, the right severance? Well, the Ministry of Labor said, you're actually owed 3 weeks' pay. They offered you 4 weeks. Consider yourself lucky. Okay. Well, he was literally about to sign this when someone, a friend of his that heard us speak before, said, wait a second. Before you sign, call Lior. And he did. And he wanted to know, is there something here that I'm missing? Well,
just a little.
Just a tiny little bit. Well, the answer for those that don't know what we're talking about, that have not seen us before, is yes. He actually was owed about 6 months' pay, John. 6 months. Not 3 weeks, not 4 weeks, 6 months' pay. Now, why this discrepancy between what he's actually owed and what the Ministry of Labor told him? Well, the Ministry of Labor can only advise individuals with respect to your minimum entitlements. Now, those minimum entitlements are only a small fraction, a portion of what you're actually owed. These are not your full entitlements, your minimum entitlements. So when he called the Ministry of Labor, they told him, yes, your minimum entitlements are 3 weeks. They did not tell him that his full entitlements are 6 months' pay. Now, those entitlements, John, for our regular viewers, they know this, are based on your age, your position, and the length of your employment. So because of that, there's no rule of a week per year of service or 2 weeks per year of service. It's not that. It's always a lot more than that. So if you lose your job, you cannot go to the Ministry of Labor. You cannot do that because they can only advise you about your minimum entitlements. You have to get some legal advice. We'll also talk about other ways to find out how much you're owed. And in this case, thankfully, disaster was averted. He got, and he will get 6 months' pay, not 3 weeks or 4 weeks' pay. So there's a very important lesson there for our viewers.
And we always say, you know, it's important anytime, whether you're 60 or 12, 20, 30, to go out and get advice on how much you're getting. But 60 in that type of business, you've got to make that phone call.
You have to.
Tough to get work.
Can you imagine if he still has to pay his bills, he still has to pay his mortgage, and his money is run out, he can't find a job? It's terrible. At least now he has more time to find a job. The other lesson here is a lot of people believe that just because you work somewhere for a short period of time, you get little severance, maybe no severance. That's wrong. In fact, John, short service employees are treated disproportionately better than longer service employees. So for this person, after 3 years of employment only, he got 6 months pay. There's nothing unusual about that. So you may have worked for a few months only, And believe me, you could easily and probably are owed a few months' pay, even if you're a short service employee.
A simple chat, a way to contact 1-855-821-5900 to get a hold of Lior, a member of his team. There's also help at employmentlawyer.ca as well through email. We do also do a 1-hour radio show and have been doing that for about 5 years. If you want to go to our employmenthourtv.ca website, find out where you can catch the show every week and every weekend as well. Get a lot of phone calls on this show, a lot of people inquiring, thinking the same things you are about their employment rights, where they stand. We'll get to one of those phone calls that we had in the show, and they'll get you to expand on it.
I was working for an employer. We were bought out by a company, and they wanted to close down the location that I was working at and move everybody to a new location. It was a good distance away from the two, like in between the two locations, about a 20-minute drive to about an hour and 15 minutes. Does the employer have to compensate their employees for moving to the new location, or is that kind of considered a way of a dismissal?
Yeah, we've heard that before.
We've heard that before, and it's actually a fairly common situation. The company decides to relocate, and now what does that mean for their employees? Well, for some employees, that may not mean much, but for some other employees, that may mean, like this person, instead of taking 20 minutes to drive to work, it's going to be an hour and 15 minutes. Well, that's a big deal. So let's break this down. What does this mean?
Okay.
This is obviously a significant change to the terms of employment. When you go from 20 minutes drive to an hour and 15 minutes, that's a big deal. A company does not have the right to make significant unilateral changes to the terms of employment. If the company does, that can result in what we call a constructive dismissal. The idea being that you don't have to accept this, you can treat that as a termination and get your severance. So this is a classic example of that, where the company now changed the terms, you have to commute so much longer, and this person now has the option. He can decide to accept this change, continue working, or he can say, no, I am not going to accept this. I'm going to treat that as a termination and get my severance. Now, this is just one example of a constructive dismissal. There's many others. It could be a demotion that's a constructive dismissal, or a change in compensation, and change in structure of pay. All of those and others can result in a constructive dismissal, so he does not have to accept it. And I would have told him, give me a call if the company still goes ahead with this change, and let's talk about getting you out of there with compensation.
What would be the hazards or pitfalls, if any, if he said, okay, I guess I got to drive?
Well, there's a number of problems. Number one, now he's driving a lot longer, so it's taking him more time. The other problem is if he realizes later, well, this was a terrible idea, I can't do this, it's impacting my family, my health, he's stuck with it. Once you do it for any period of time, now you're stuck with this. Now it becomes a term of employment. And beyond that, once he's given the company the chance to make this change, they can do it again and again. There's this precedent created.
Wow.
So once a company gets away, quote unquote, with a change, it's as if you're telling them, hey, that's okay, do it again. And the next time they do that change, you're stuck. So you only have one chance to deal with a change to the terms of employment. If you don't, you may find out later that you've given the company the right to do it again, and that could be a huge problem.
If this guy really loves his job, can he meet them halfway and say, guys, you know what, I know it's a long way, I don't know if it's going to work, can I just take it out for a spin and give it a shot? If it doesn't work, then I'm not doing it.
Yeah, he can, and he probably should do that, but he can only do that if he says so explicitly.
Okay.
Rather than say, well, I'll try it and see what happens, I would tell the company, and in writing, I'm concerned about this, I don't think this is going to work out, but I'm willing to try it. So I'm going to try it for the next 3 weeks, and after that, I'll let you know how it's working for me. If he says that to the company, he does have a period of time to try it out, but he has to say so, and even that period of time is short. It's only a few weeks. Beyond that, if he does it for longer than that, he's going to be considered to have accepted it and then be stuck with this change.
Contact his help at employmentlawyer.ca. You can do that, or 1-855-821-5900 to contact Lior. This show, we cover a lot of topics, and we like to break them down and get into different subjects that concern people. And one we thought we'd talk about this week, because a lot of new listeners, a lot of new viewers haven't caught the show before. That is shattering severance myths. The first one I'm going to throw at you, we did cover this on the week that was, but we'll go through it again just to hammer it home, and that is when you're fired, you only receive 1 or 2 weeks for every year of service.
That is the most common thing that people believe when you lose your job. Oh, if I lost my job, I know I get a week's pay for every year of service, or maybe it's 2 weeks' pay for every year.
My dad told me.
It's my dad told me, my Uncle Bob. I read something online. Maybe I even contacted the Ministry of Labor. Right? So no, let's make that very clear. If there's one thing I want you to take away from today's show, is that's wrong. There's no rule. Absolutely not of a week's pay per year of service. It's, as I said before, it's based on your age, your position, and the length of your employment. So the longer you work, the older you are, and the more senior a position you have, the more is owed to you. So some people that may mean 8 months pay. Some people that may mean as much as 24 months pay. So it's not a direct connection, a week per year. None of that is true. And because people believe that, John, and they end up accepting pennies on the dollars. Employers almost count on the fact that people are not going to know what they're owed, and they get away with it. 9 out of 10 times when people lose their job, they're offered inadequate severance and accept it because they don't know any better. So if you're watching us right now, you know better, and you should tell others about it. Don't let people that you know, your friends, your loved ones, accept tens of thousands of dollars in severance less than what they're owed. It happens every day. Shouldn't happen to you.
Shattering severance myths. That's what we're doing here. You might have a eureka moment as we go through these because some of this stuff you might not know if it's your first time catching the show. Another one is your employer says you've been fired for cause, so severance is not in your future.
Right. Yeah, very common. My God, I get calls like that all the time. So let's break this down. What does cause mean? A termination for cause, which means you don't get severance, can only happen if an employee is guilty of very significant misconduct and it's repeated and there's no possibility of rehabilitating that relationship. That is extremely difficult to establish. So you may have done something wrong and lost your job, but that does not mean that the company can let you go for cause. You would have had to do something awful for the company to let you go for cause without compensation. And most people, when they're go for cause, that's not cause. The company pulled the trigger before they should, and that's a wrongful dismissal. So even if you did something wrong, you are probably owed your full severance. So important then to get some legal advice.
You're talking things like theft, violence in the workplace, but stuff like, you're late for a couple days of work. Stuff like that's not good enough, but the other ones are. Right?
Absolutely. Yeah. And some people do things that they're not supposed to. Maybe they're late. Maybe even they talk rude to their boss. None of that is good.
Right.
But it's not cause. Yes, if you hit somebody, if you stole, that's cause, full stop, end of story. But for most people, the type of misconduct, sometimes it's performance. The company says you're not doing a good job, your performance is not good, so I'm going to let you go for cause. It's almost impossible to let someone go for cause because of performance reasons. And if that's what's happened to you, if the company says they have cause, you better give me a call.
1-855-821-5900, that number, help@employmentlawyer.ca as well. We are shattering employment myths. Write these down if you're quick enough, or at least remember them. Another one on the list here is being on contract means you don't get any severance.
Yeah, and being on contract, it means a lot of different things to different people. Oftentimes when people talk about being on contract, they talk about being an independent contractor. When they're not really an employee, and they think, well, if I'm an independent contractor, I don't get severance. We'll talk at length about independent contractors in future shows, but I want our viewers to understand that just calling yourself an independent contractor doesn't make you one. Most people, where they in fact supposedly are independent contractors, the law still considers them to be employees. If you have a regular job, you go to work, you work for the company under their direction, you've been doing it for a while, you're likely an employee. It doesn't matter what you call yourself. It doesn't even matter how you pay your taxes. The law will consider you to be an employee, which means you have the rights of an employee, overtime, vacation pay, and it also means you have the same severance rights as an employee. So calling yourself an independent contractor doesn't matter. The technical term that I like to use, it's very complicated, hopefully everyone understands, is if it looks like an employee and acts like an employee, it's an employee. It
could also be complications when it comes to CRA as well if you've been doing that incorrectly under the guise that you're an independent contractor. That could come back and bite you severely.
Absolutely, both company and individual. So it's important to get it right. So if you're not sure if you're an employee or an independent contractor, if you're not sure what those rights and entitlements are that you have, give me a call.
Shattering those severance myths. Another one, short service employees get very little severance. Again, this goes back to our week that was. It was, a month per year, a month.
Yeah, I've had clients that have worked for 6 months and they thought, oh, I'm lucky if I get a week's pay, when in fact they were owed 4, 5, 6 months pay. So I've said this before, so I won't talk about it at length, but short service employees, not only do they get severance, they get significant severance, because just because you work somewhere for a short period of time doesn't mean it's going to take you less time to find another job. So doesn't matter, a month, 2 months, 6 months, 20 years, all individuals get severance. Again, age, position, length of employment. You're not sure? Happy to talk to you.
The last one on the list is really important, and this has cost thousands of dollars to thousands of people, and that is your rights to severance expire if you don't accept their offer deadline. Friday at 5, you got to have this signed and back to us, or whatever the case, right?
The old deadline. And every single severance offer is going to have a deadline. You better sign this by Friday, Tuesday, whatever the deadline is, or else you don't get it. And think about it. If you just lost your job, your employer's offering you money, and it's going away if you don't accept it, you're going to be stressed out. You're going to feel the pressure to sign it, and probably you're going to sign it because you're feeling that pressure. That's what often employers are counting on. So no, that severance deadline is meaningless. Your legal rights don't expire Friday at 5.
Right.
In fact, you have 2 years to pursue those rights. So that deadline is a pressure tactic. You have to understand what you're actually owed. Because if you sign this because of the pressure tactic and you realize the next week that you were owed another $50,000, which is extremely common, it's too late. You can't go back. So that deadline doesn't expire. That package doesn't expire. Regardless of what the company says, you're owed what you're owed. Get some advice. Make sure you understand what you're signing, what you're owed. Once you sign, it's too late.
It's 1-855-821-5900, help@employmentlawyer.ca. Severance Pay Calculator, we'll get to that, and navigating through a performance improvement plan after we take a short break right here on Employment Hour in 30. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Welcome back to Employment Hour in 30. John Scholes, Lior Samfiru. The number anytime to reach Lior and the firm, 1-855-821-5900. It is help@employmentlawyer.ca as well. We've talked about it a few times. Severance Pay Calculator, a very important tool, very simple to use, and we're coming close to 500,000 people having gone through the system and use the calculator. Give me some details on how it works.
Well, we talked earlier in the show, John, about calculating severance, and I told people it's based on your age, your position, and the length of your employment. Well, anyone should be able to get this information quickly, even without calling a lawyer. So I created a tool called the Severance Calculator. Very simple. You go to SeverancePayCalculator.com. Again, SeverancePayCalculator.com. When you go there, they'll ask you for your age, for your position, and the length of your employment. Answer those questions. It's anonymous. It takes seconds. You don't have to put in your name. And once you do that, you find out exactly how much you are owed, whether it's 2 months severance, 6 months severance, 24 months, or anything in between. It's such an important tool. It's the easiest way, the most accurate way to find out how much you're owed. Maybe you lost your job and you're looking at the severance letter, or you haven't. You're worried about losing your job. You're thinking something may come down the pike, and you want to know what you're owed to be prepared. SeverancePayCalculator.com. And please don't be surprised by the number. The number is accurate. It gets rid of these myths of a week per year of service or 2 weeks per year of service. Or close to 500,000 people, John. 500,000 people have used it. We're very proud of it. So if you haven't used it before, use it now. And, make it a nice, fun party game. Okay, let's find out who of your friends gets the most severance.
That'll be minutes of fun.
Minutes and minutes of fun. No, but it is great because people think, I don't need to use it because I know I've been there for 3 years. I get 3 weeks. Wrong. Think again. Go to SeverancePayCalculator.com right now. Find out how much you're owed. And if you want to, you can contact me directly from the Severance Calculator. You don't have to. You have that option. So I can help you get what you're actually owed.
And this is nothing you're ever going to find on the Labor Board website. Nothing close to this. So
no.
You got to go here.
Check it out. It's free. There's no strings attached. It's just there for your information. If you don't check it out and if you lose your job, honestly, you're missing out.
I want to get to an example, and I'll let you expand on this one, Lior. Sarah says, worked for 4 years as an office manager. A few months ago, new senior manager was hired, and almost immediately they began verbally abusing her. Sarah was repeatedly mocked, told she was useless and too old for the job. That's nice. She's 54, still young. After Sarah complained to HR, she was fired. The company said that because she'd worked there less than 5 years, she was not entitled to any severance.
Wow, there's so much to unpack and break down here. So first of all, this clearly is a human rights issue. If she's been mistreated, called too old, etc., and then fired, that's a human rights violation. A company doesn't have a right to treat someone that way. It doesn't matter how much they're paying them. It's illegal, full stop. So this company is going to be liable for human rights damages. It's going to be liable for its behavior. It's going to have to pay for that. That's wrong. You can't do that. Now, this issue of the severance, she's worked for less than 5 years, she doesn't get severance, wrong. Another misconception. So not only does she get severance, let me tell you how much she gets, but let me actually run this through the Severance Calculator. Again, SeverancePayCalculator.com. So she's an office manager, worked for 4 years. She's 54 years old. We see it right here. Someone in her situation would be getting 8 to 9 months pay. So Severance Calculator tells us, I tell you she's owed 8 to 9 months pay. So not only does she not get something, as her employer was saying, she actually gets 8 to 9 months pay. That's why it's so important. So I would have told her, call me. Not only do we want to make sure to get you that 8 to 9 months of severance, there's human rights issues here. You can't be fired because you're old. You can't be fired because you're complaining about harassment. That's wrong. That's illegal. And there's going to be repercussions.
What a pressure relief when she finds out that she actually not only gets some severance, but a wealthy amount, right?
Well, what does that money do? It buys you time to find another job.
Right.
You're not going to find another job tomorrow. You're probably not even going to find a job in a month. Certainly not a good job. So that severance is there to help you bridge the gap from job 1 to job 2. It's so important because if the severance money runs out and you don't have a job, what do?
Right.
How do you pay your bills? That's why it's so important to get advice.
SeverancePayCalculator.com one more time, and EmploymentHourTV.ca if you want to check that out. You will find where you can listen to the radio show that we've been doing for several years, the Employment Hour. Take a lot of phone calls on the show. A lot of interesting stuff comes across the phones. We'll get to a phone call and have you comment on it, Lior.
Our company's doing some restructuring. They will be getting rid of people. I'm just curious to know, I'm a network professional, so our salaries are based on an X amount every year plus bonus, and that bonus varies depending on how profitable the company was. So if you're making in the mid-80s, you ended up getting close to, like, let's say 100. When they do give you a separation, will they base it just on your salary?
We've had that phone call as recently as last week.
Yeah, we have had it very recently, and we talk about this often because the question often becomes, okay, I know my salary has to be included in my severance, but what else is included? And a big one is bonus. So let's make it very clear. When you lose your job when it comes to severance, it's not just salary. It's all components of your compensation have to be included. So that's salary, that's bonus, that's benefits, that's car allowance, that's stock options, et cetera, et cetera, et cetera. So with respect to bonus, yes, bonus has to be included. And if your bonus varies from year to year, we'll simply look at an average. Let's say we do a 3-year average, and we'll see, okay, if your average bonus is $12,000 a year, we'll use that figure to calculate your severance. So when it comes to severance, it's not just the number of months that you get paid, it's also what's included in it. Companies not going to forget about salary, but they may often, quote unquote, forget about the other components of your compensation, and that would make it still a wrongful dismissal.
What if the employer is a little bit sneaky and they let you go, I don't know, a month before the bonus is supposed to be brought out? Or for that matter, if you're in a sales position and you had commissions that you'd already done work on, you were just waiting to get those commissions.
Yeah. And you know what? Some people may think, well, an employer will never do that. Trust me, yes, it happens. I've spoken with hundreds of people over the past years where that's happened. So a company can't find a convenient termination date to avoid monies that they owe you. If you've earned the money, they have to pay you. They can't avoid that by saying, well, I'll fire you the week before the money is paid. It doesn't work that way. Not only does it not work that way, a company that tries to get away with that may get punished, may have to pay additional damages for this bad faith conduct. If you've earned the money, the company has to pay it.
We'll take a short break. Returning from maternity leave. This is an important topic we'll get to. 1-855-821-5900 and help at employmentlawyer.ca. More Employment Hour 30 coming up.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact: the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact: over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
The number anytime to contact Lior and the firm, 1-855-821-5900 and help at employmentlawyer.ca through email. Lots to get through here still on the show. We'll get to a phone call though from our radio show, which we do every week and have done for about half a decade. Surprised it's been that long. We're still there. Somebody's still keeping us on. You can check it out at employmenttv.ca, employmenthourtv.ca to find out a station where you can catch the show. Another phone call right here.
I've been working for a company approximately 20 years in the office doing secretarial work. They've now given me a letter that they're going to take me off salary and put me on an hourly rate. And then there was a clause of termination without cause and no severance pay. I would not sign this. I wanted your opinion.
Yeah, well, so first of all, good call, don't sign it.
Yeah.
And a general rule, if a company comes to you once you're already employed and wants you to sign a new employment agreement, bad news. There's a reason for that, and that reason is not to give you something better than what you have. So oftentimes, it's exactly as with this lady, the company wants you to sign an agreement that limits your future severance. So terrible idea, don't do that. Now, in this situation, if they want to change her compensation from salary to hourly, well, that could easily and probably is a constructive dismissal. It's a big deal to go from salary to hourly, and frankly, the other way as well. Company does not have a right to do that. So she has the option, first of all, she could say no, but if they go ahead, she has the option to treat that as a constructive dismissal. So what does that mean for her? That means she gets severance. How much severance? Well, I've taken the liberty of taking this information and plugging it into the severance calculator. Again, severancepaycalculator.com. So what does that mean? She's in a clerical position, been there for 20 years. I pick an age, let's say she's in her 50s. And what does she owe? Well, 16 to 18 months pay. 16 to 18 months pay. And remember, John, her employer wants her to sign an agreement to give this up. Don't do that, please. So because the company is changing how they pay her from salary to hourly, then she can say, no, I'm not going to accept that. That's a constructive dismissal, and give me my 16 to 18 months of pay. Very important to understand this concept of constructive dismissal, and certainly to use the severance calculator.
You know, if you have other questions when we're not doing the show or the radio shows for that matter, there is another outlet for that. It's terminationquestions.com. You go to terminationquestions.com, ask your question, you'll answer it. Member of your team will answer it, and you'll get the information you're craving. After that, you can make a phone call or use another outlet like email as well. But here's one from Termination Questions. Lior, I'll give it to you. It says, my wife was nearly at the end of her maternity leave when she called her employer to mention her return to work. She was told that she would only be receiving half as many hours as she was getting before her leave. Are they allowed to do that?
Wow. No, and you know, I think always that when we're talking about maternity leave and treating employees coming back from maternity leaves, companies by now, I would hope, know better. But unfortunately, often they don't, and this is just an example of that. So let's make it very clear. A company doesn't have the ability to change the terms of employment for an employee coming back from maternity leave. That's prohibited under the Human Rights Code. It's prohibited under the Employment Standards Act. So no, they can't say, we're going to give you less hours or a different job. If they do that, and it doesn't matter what the reason. Maybe they like the replacement better. No, they have to take her back to the same position. By failing to do that, not only is this a human rights violation, which means she's owed some compensation right there, it's also a constructive dismissal. Again, back to this concept of constructive dismissal. They change the terms of employment. So she's going to be owed severance if she chooses to pursue it. And the problem is, if she accepts this reduction in hours, reduction in pay, then they could do it again. She's given them the right to do it. They'll be able to do it again. And at that point, she'll be stuck. So no, this is illegal. And if you're coming back from maternity leave, remember, you have a right to your same job, the same term, same compensation, same bonus, same everything. And if that doesn't happen, the company's almost always going to be liable. You have to give me a call.
Same applies for paternity leave as well, right?
Absolutely. Yeah. Fathers, mothers, if you take a paternity leave, parental leave, you have those rights. You can't be penalized, by the way, John, for taking that leave. The company can use an excuse such as, oh, you're on probation, so we're going to let you go. We've had calls like that on the show as well. So no, you can't be mistreated in any way, penalized, father, mother, and you have to be taken back to the same job.
We joked about it for years. Don't mess with mama. It's going to be a t-shirt one day. It's true.
Or papa, for that matter.
Or papa, right. Good for another week. You want to contact Lior now that we're done, 1-855-821-5900. There is help at employmentlawyer.ca and always employmenthourtv.ca as well. That website will lead you to where you can find the radio show that we do every week as well. So next time, we'll catch you next week right here on Employment Hour in 30.
This program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.